All right. Mr. Derby, I think this is your motion for adequate cause.
Yes, Your Honor.
You want to address that briefly?
Well, he's been running away after he filed the CPS report. The last month he's been with me permanently. His mother has tried to come and get him, but he's just so deathly afraid to go with her that he's refused to go with her. He just seems really scared. I don't know what exactly is happening at his mother's home, but he's really adamant about not going there. So like this week, he was supposed to be with her, but he refused Friday. So he's been with me still. It just seemed like things got a little bit worse for him at her home after the CPS report was filed.
Okay. Ms. Hyatt, have you looked into this matter at all?
Your Honor, this is an old case. I was appointed, I believe, back in December,
Right.
and I did have contact with Destin at his school. It's been many months ago, so I don't. At that time, it was decided that there was not adequate cause, and so I set the whole matter aside. So I kind of dipped into it and then stepped back. I have no new information for the court today. I don't know how you want me to proceed.
Okay. Well, first of all, if I find adequate cause today, do I need to reappoint you, or do you think that the old appointment is sufficient?
Let me look at my orders appointing. I guess one change would need to be made. I was supposed to have a report filed by January 4th of 2023. So obviously I missed that.
All right, well, let's, all right. Well, let me make a decision on the adequate cause first.
Okay.
Earlier, I read the requirement for adequate cause. Again, that's at RCW 2609-260. And it's the court shall not modify a prior custody degree or parenting plan unless, and I'm skipping some of it, it finds that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child. And from what Mr. Derby has presented in his motion, I believe he meets that standard. So I am going to sign your order for adequate cause.
Thank you, Your Honor.
I'm going to do an amended appointment of Ms. Haidt as the guardian ad litem. And she will need to do an investigation that will assist the court in making a decision down the road. What will happen eventually, Mr. Derby, is this will be put on the trial setting calendar and set for a trial on the issue of the parenting plan. Ms. Haidt needs enough time to do a report before that. And so I'm going to keep this case on my docket for the time being so that I can at least track that report. I'm going to set a review hearing for April 12th at 9 o'clock. That will be simply for the purpose of determining if Ms. Haidt has met with the parties and whether she's got all of the documents she needs. I'm not expecting a report at that time, But I do want to make sure things are going forward. When it's clear that Ms. Hyde has completed her investigation, then Mr. Derby, I'll direct you to put this on the trial setting docket so you can set it for trial. Okay.
Okay, thank you, Your Honor.
All right,
In the meantime, Your Honor,
yes,
I'm just concerned. I'm concerned about my son and how he's absolutely just dead set on not going back to his mother's home. I was just curious if I know that the police have been called. He's ran away. He was even put on the runaway list. I just hope that we could keep him at home until this is found. It's hard to send him somewhere when he acts so scared.
what
It's fine. Okay, you got to be quiet.
I just let a couple people in. Is either of those Melanie Vianola? Doesn't appear to be. So I don't know that today I can change the parenting plan. Here's what I would suggest you consider is if you think the mother is a threat of harm to your son, maybe you should bring a motion for a restraining order. And I can consider that and perhaps put some restrictions in place.
Okay, Your Honor.
All right, but right now, based on what's in front of me, what I'm able to do is say, yeah, there probably is enough evidence here that we need to revisit the parenting plan, but I don't know that I can change the old one at this point. Okay.
Okay, Your Honor.
Okay,
Your Honor, if I might just ask one quick question.
sure.
If on April 12th, you're really looking for just a compliance review that the parties are engaged, and then do you have an idea that you would also like a report from me at a future date? And if so, do you have a timeline in mind for that?
Maybe you could help me with that. I would hope we'd have some type of report by say May,
Okay.
either mid-May or late May.
Okay.
Okay.
I may have some other verbal information for you on the 12th if I'm able to visit with the parties before then as well. But I'll for sure attempt to have a written report then on the date that you set for May.
Okay.
Thank you, Your Honor. I appreciate that guidance.
All right. Thank you.
Family law self-represented docket. If that isn't the type of case that you are logging in for, please go back to the Cowlitz County Superior Court website and triple check what courtroom you're supposed to be in this morning. We'll go ahead and get started. I'm essentially going to call our cases in order. We have 4 cases on the docket. So the first case I'm going to call, there's some folks having trouble getting into the Zoom room. Give me just a minute to help them out. Okay. The first case I'm going to call is 13-3001025. This is Donald Derby as the petitioner, Melanie Vianola as the respondent, and I believe we have guardian ad litem Ann Height with us.
Yes. Good morning, Your Honor.
Good morning. So what I believe we are here for, and some of you may know the typical judicial officer who's probably heard a lot of the matters in your case is not here today. So if I am mistaken, please correct me. But what I believe we're here for is to determine a restraining order. Looks like a temporary restraining order, emergency restraining order was signed. Does that sound correct to the party?
Can anybody hear me? This is Melanie, part of the party.
Yes, we can hear you.
Okay, I'm trying to get re-logged in so I can see if I can get 1 second.
Yep, absolutely. We'll give you a minute.
Thank you so much.
So we'll just pause here for a minute while she gets logged back in.
Almost there. Sorry.
No,
about that.
no, no problem.
Okay, I'm in. There we go. Thank you so much.
Yes, absolutely. And you said you are Melanie.
Yes.
Okay. So does that sound right to the parties that what the folks are prepared to proceed on today is whether this restraining order should be entered?
Yes.
Yes, Your Honor.
Okay. So what I will do in order of how we proceed is, Mr. Derby, I'll let you know what I have reviewed for filings. I'll let you make any arguments to the court that you want to. Ms. Vianola, I will let you respond. And then I am going to get input from GAL if there is input to give on this matter. Okay. All right, so Mr. Derby, what I do have is a motion for immediate restraining order that was filed on or about March 21, 2023. And I have reviewed that. And first, what I'll have you do is just raise your right hand and we'll swear you in for testimony that you're about to give. Can you raise your right hand? You swear and affirm that the testimony you're about to give on this matter is the truth, the whole truth, and nothing but the truth.
I do.
Right. Can you state your full name and spell your name for the record?
Donald Jeffrey Derby, DONALD JEFFREY DERBY.
And are the statements that you made in the, it looks like the March 20th petition filed on March 21st, are those statements true and accurate under penalty of perjury?
Yes, ma'am.
Okay, so go ahead and tell the court why you are asking for this restraining order to be entered.
Well, at this time, my son had been feeling so scared and he had been running away. He ran away 5 times. Twice the police were called. One time he was put on a runaway list. The things that he says that had been going on in the home, he's a 15-year-old boy who's over 200 pounds, and he was saying that he was scared all the time, and if they weren't yelling at him and doing whatever was going on, they were fighting with each other. There's a constant feud going on. He'd been getting slapped, punched. He had shoved against the wall. Things were being thrown at him. And he was always saying that if they get around alcohol, then things get even worse. So at this time, I just feel that for him to feel safe and secure and to be happy and just to concentrate about schoolwork and doing his 9th grade work, I feel it's very important for him to stay in the one home until the courts can come to a trial and a final decision.
Okay. And I do see that you have also filed that order for adequate cause, which was granted to more permanently amend the parenting plan. Is that correct?
Yes, ma'am.
And you're just awaiting a hearing date on that, it looks like.
I think it's in May.
Okay.
So I guess I was hoping to have this restraining order in place until May, and then just go by whatever parenting plan we come up with.
Okay. Okay, thank you for your input. Ms.
Thank you.
Vianola. Do you object to this restraining order being put into place temporarily?
Absolutely. 100%.
Okay, so let's go ahead and have you raise your right hand. You swear and affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Let's have you state your full name and spell your name for the record.
It is Melanie Rebecca Vianola, Melanie Rebecca, V as in Victor, Ienola.
All right, so go ahead and please tell the court why you are objecting to this restraining order being entered at this time.
I'm objecting to it because there is absolutely none of this it's never happened. There's actually a CPS report. Nothing was founded. This is the third CPS report that has been done on us, and nothing has been founded. And we are now going on our third guardian ad litem. And the first two were definitely not in the favor of what Mr. Derby's saying. And it's kind of the same thing, only it's progressed. The things he has now accused me of are heinous, absolutely heinous. I work with children, and I could lose my job had anything come of it for any reason. My son, I have not seen in over a month because he is not following the current parenting plan. So I don't really know why he thinks the paper today matters, or what he says matters, when he can't even follow the current parenting plan. That is a concern to me majorly, that not only have I not seen him, he's withheld him from my parents, whom they have wonderful bonds, and they've seen my son every other week for the past 8 years. And he has not been able to contact any of us. And I've also not contacted Mr. Derby since March 21st. And when I did, it was a message from the school about Driston using his phone. And it was just a photocopy of that, and asked if he had seen it. I actually have my father here as well, because I think what's best for Driston, honestly, at this point, is to be out of both of our homes. And Mr. Derby said that my dad's house is a safe place. He loves his grandpa, and it's a mutual ground. And it's a place where Driston can be safe and feel like he can speak freely. And I hate saying that, because as a mom, that's the hardest thing to do. But I don't think he's in a good position right now, where his dad has been keeping him from everybody and isolating him completely.
Okay, and I'll just state for the record, I won't be deciding any sort of alternative placement for the minor child at this point. That could be something that you address when you all go to a full hearing on any modification of the parenting plan.
Okay.
Anything else? Yeah, anything else you want the court to know?
I mean, I really don't, that other than I know that everything he's saying is so not true, and it's slanderous. I've been defending myself for 13 years in this court system. That's all I've been doing. It's not about Driston and what's best for him. I have been defending my character and who I am, and my husband's character, and my oldest son's character. That's all this is.
All right. Thank you for your testimony.
Thank you.
Ms. Height, I know that you recently, at least based on my review, you had some interactions previously in this case and then were reappointed. And I know that was fairly recent, so I'm not sure how far that new investigation essentially has gone. So I'll turn it over to you at this point to see if you have any input for the court.
Thank you, Your Honor. That is the situation. I was originally appointed in November of last year. Adequate cause was not found at that time, and so I set everything aside. I was reappointed on the 15th of March and re-engaged with the parties to see if we could get some traction to get the intake packets returned. I had already received Mr. Derby's packet, and I've been assured in a conversation with Ms. Vianola yesterday that she's going to get that packet and payment to me so that I can get underway. I will tell the court this morning that in my previous appointment, I did speak with Driston at school, and we had a good conversation. He did express at that point some discomfort being at mom's home, but Driston he's a complicated and special young man, and I don't know if it was something that was bothering him that particular day. I got the impression that things change quite often with him. There's seemed to be a fair amount of volatility in the homes, and I think volatility is probably too strong a word. There seems to be some uncertainty and instability for him in his thinking and behavior in the home. So all that to say, I don't have any fresh information. I haven't talked to Driston since I was reappointed. And so hopefully that will get underway soon. My final report is due on May 10th, and I have every expectation that I can meet that deadline.
Yeah, and I do see there's also, unless this has been stricken for some reason, it looks like there is a compliance review set for April 12th. So just next week. Does that sound correct to the parties?
Yes, ma'am.
I've never been served with any papers of that, so I had no idea.
So this was set during a March 15th appearance where I'm just looking to see if you were present. It doesn't look like you were present.
I missed it because I received in my filed papers basically a judgment that had already been made is what it looked like, but it had not actually been filed. So I thought a judgment had already been made. My mistake for not looking further into that. But yes, I did miss the court date. So
So yeah, and so I would let you know what the court does have based on that March 15th hearing where you weren't present. They did set a compliance review for April 12 at 9 a.m.
okay.
So that would be next, what is that, next Wednesday or Tuesday? I don't have a calendar in front of me. Next Wednesday. So this same docket at 9 a.m. next Wednesday.
Your Honor, I'm just wondering if, in view of the fact that I have spoken to both parties since I was appointed and have had assurances that I have one intake packet and I have the assurances that I'll be getting the other one shortly. And I don't believe payment is going to be an issue either. If it would be worthwhile to strike that, I would say at this point, as far as we could have gotten by now, we are in compliance. And I don't anticipate a problem getting the other information that would be reviewed at that time, although I'm perfectly willing to come back next week.
Well, yeah, let's come back to that issue. This is what I couldn't see. I do see the order regarding adequate cause granted to send the parenting plan amendment to a full hearing. Has there been a date set for that full hearing? I know, Mr. Derby, you mentioned something in May, and I'm just not seeing that.
They said May 3rd, but I'm not sure if that was actually set in stone.
Okay, let me check with the court. Are you able to see if there's been a date set on that? The last thing I have is the March 15th order finding adequate cause to send to a full hearing, but it doesn't actually have a hearing date in there. Oh, before setting it. Yeah, okay. Right. Can we do that today? Or do they need to do a motion note for motion docket for that to be set? Whatever your preference is. The trial assignment, yeah. Okay, let's do this just because I think there is not a date set yet for that full hearing. And Commissioner Nelson would be the one handling the April 12th compliance review, just to kind of make sure we're ready to go. Let's go ahead and keep April 12th at 9 a.m. I'm sure it can be, very brief, just to determine if we're ready to set that full hearing date. And then the parties would note this for an actual hearing date.
Just to see your son.
Okay. Now let's go to the restraining order. Ms. Height, do you have any input to the court as to whether a temporary restraining order would be necessary to protect the minor in the meantime? And I see that the court issued an emergency one. I'm kind of in a position where it's essentially he said, she said. I don't really have any documentation in front of me. So, and I do see the prior parenting plan based on a full GAL investigation at that time did not put a restraining order into place. So, any thoughts or input from you?
I don't have any recent contact with Tristan, and this week is spring break. I would have preferred to speak with him at the school, but I think I would have a little more forthcoming conversation. So my hope is to speak with him next week. So all that to say, Your Honor, I don't really have any fresh information that I think would be helpful this morning.
Okay. Well, here's what I'm inclined to do. I think because the prior commissioner put an emergency order into place, I am going to temporarily re-up that until there can be further investigation. The reason I'm doing that, Ms. Pianola, is not in any way to say that I necessarily am making any ruling on the veracity of the statements that are made, but I do think it makes a lot of sense to have this further investigation and have Ms. Height be able to talk to the child before we make any permanent decisions on that. So what I'm going to do now is actually go back and reverse my prior ruling on that review date. I think what we should do is set out the review date a bit further, and then I'll make this restraining order temporary only through that review date. So it would essentially be a new compliance review date as well as a review of the restraining order. And hopefully at that time, we'll have a little more feedback as to whether this needs to be a longer term restraining order or not. So with that said, I'm kind of thinking 2 to 3 weeks at most. Ms. Height, what would be your preference?
Well, in view of the fact that everyone wants to get some stability for this young man, I think the 19th would work. If that would be 2 weeks. Yeah. And what I will attempt to do is have contact with him, and then I would like to file a brief written report, just really an information for the court so that everybody's on the same page when we come back on the 19th. So it might come in later than I normally would like to. I would like to file it 3 or 4 days ahead of time, and I will attempt to do that, Your Honor.
Yeah, that makes perfect sense, and I appreciate that. And I think, so Mr. Derby, Ms. Vianola, instead of coming back next week on April 12th, I'm inclined to strike that and instead reset this for review, both compliance and restraining order for April 19 at 9 a.m. Does that work for the parties to log back in here Wednesday, April 19 at 9 a.m.?
Yes, Your Honor.
Okay. Ms. Vianola, does that date work for you?
I mean, I haven't seen my son in over a month. Is there any way I can do a supervised visitation with him with a mutual or a parent's place? I think it's really difficult to say that it's fair to Dristan or to either one of us that he hasn't seen me in not just a month, that's just been solid, has not seen me, but it started 6 months ago.
Yeah.
And
Yeah.
now this is actually my spring break. And that's a long time not to see your mother and be isolated from both parties. And now I can't have any contact with him without any valid, I mean, even a CPS report was done and nothing was found of it. So I
And
just don't,
excuse me, Miss Vianola, does Driston have like FaceTime capabilities on a phone or some other electronic device, or a device that he could access? Because I am inclined to allow electronic communication, because then I know that it's his wish to, reach out to you. And I think
Right.
that's very valid for the next
in our
2
parenting plan, he does have that right. Unfortunately, I don't get to talk to him on the phone. I only get text messages, and I know how Driston speaks, and it is not Driston. I can't guarantee who I'm talking to, and he hasn't called my parents. He hasn't called anybody. So I have a hard time believing he has free access. Mr. Derby will say he does,
Okay.
but I can't guarantee that.
So Mr. Derby, what I am inclined to write into this very short-term 2-week restraining order is that all forms of electronic and phone and video communication will be allowed. And I really do recommend that you allow that to occur, and that you allow that to occur privately, where, you're not standing over the child and the child doesn't feel like they have to please both you and Ms. Vianola, that this is time with his mother. Is that something that you can make sure happens?
Yes, ma'am. He has his own telephone and his own number, and she has it. I ask him all the time if he wants to call his mother. He says no. He absolutely does not want to. I'm doing this for him. In the prior cases, he's been so young that he wasn't able to really say what he wanted. And now that he's actually getting older, this is why this is occurring again, is because he's actually able to tell the truth of what's going on. But he has his own phone number. He has it with him 24/7. So even at school, he has it for any kind of an emergency calls. And everybody has his phone number.
Okay. So I am writing that specifically into the order. So Ms. Vianola, all forms of electronic communication, including phone, text, email, FaceTime, those are allowed. And I would encourage the parties to do that, to keep that parent-child connection through this rocky 2-week period that, we will get through. And we'll be back here on April 19. I'm going to finish filling out this order. Just hold tight with me in case I have any questions for you.
I do have a question while you're doing that really quick. Would it be possible to meet at his school during a free hour with his caseworker during the day? If it's a free hour.
And someone's trying to speak over you.
I hear that. Sorry.
If you're not actively in front of this court on a case right now, please mute. Otherwise, the court will mute for you. Go ahead, Ms. Vianola.
So I know Mr. Langenbach is his caseworker at school. I know he has 2 periods, or he was having 2 periods with him. And he also has a counselor that I had, asked them to kind of check in with him periodically because of everything. Is it possible that I could meet him at the school with the counselor? And if it's a free time, lunchtime, if that is something he would like to do during these 2 weeks, I don't want to step boundaries where I don't know what my restraining order is, other than I can't be within 50 feet of him.
Yeah, I think what I understand what you are asking And I think just for this 2-week period, I'm gonna leave it as no in-person contact until the court has a better idea of what exactly is going on here and what the wishes of the 15-year-old are and what the concerns potentially are. So hang in with us for these 2 weeks. You know, I'm going to put in the exception for electronic communication, but I'm not inclined to do any in-person contact at this time.
I want the courts to really know that Driston, you know, he is, like the GAL said, unique, and he's functioning not at a 15-year-old level. He functions at a
Away
6th grade
from me.
level. And his doctor's notes say that, his teachers say that on the new IEP we just did. So it's very important to remember that, yes, normally a 15-year-old, you know, can be very capable of making these kind of decisions or understanding things. He is not 100% there.
Oh boy, see, this is why he needs to get away from her.
I don't find it funny. Sorry, Mr.
Oh.
Derby.
No,
I'm
it's
gonna have to meet some folks here.
I already filed it all.
Okay. And again, I certainly understand the concerns. I do hear you. It's not falling on deaf ears. I just, I think that given where we are at and the fact that we can get you folks back in 2 weeks, I'm just going to leave it as is now with electronic, phone, video, all of that strongly encouraged, allowed and strongly encouraged. So Mr. Derby, I hope you're hearing me say that I am hoping that Ms. Vianola and her son stay in contact electronically through this 2-week period. I think that will be important for both of them.
Thank you.
And then I'm going to check the box on this, that because you were both here, although virtually, that this restraining order doesn't need to be served on you, Ms. Vianola, by law enforcement. I think that's kind of overkill in this situation. But what I would encourage you to do is anytime later today, reach out to the clerk's office or come by the Superior Court clerk's office and get a copy of it.
Okay.
Because then if any issues come up with, you know, was electronic communication allowed, that sort of thing, you're going to actually have that in hand.
Okay. Thank you.
Oh,
Yes, sir. I saw you raise your hand. Go ahead.
I was just was going to let the courts know that she was served by the sheriff's department.
And sir, what I'm talking about is this order that I'm currently signing. This one is a little bit different than the emergency order that Commissioner Nelson signed, because it does allow that electronic communication. It also gives a specific expiration date of April 19, 2023 at 9 a.m., which is when you folks will be back in front of this court. And I will make sure that Commissioner Nelson, he will see it in the notes, but I am going to shoot him an email just to know that this is also an issue he'll need to address on April 19th if this restraining order needs to be re-upped, because the default is going to be that it lapses on April 19th at 9 a.m. Okay. Okay, I have got this filled out. I'm going to hand it up to the clerk. And just so I make sure we send it to the right law enforcement agency, Mr. Derby, what are you in Longview city limits? Kelso
I'm in the Kelso area.
Okay. Are you in city limits or sheriff?
No, I'm out past Ostrander.
Okay. Would that be the Cowlitz County Sheriff? It is. Okay, perfect. All right. And then, ma'am, these are really odd questions. But in these restraining orders, they require we enter some identifying information. So hair color, I'm guessing brown, but might be red. So tell,
It's brown,
okay. And then what's your eye color?
brown.
Okay. And general height and weight, very awkward things to talk about.
It's okay. I'm a 5'3¼ and I weigh about 155.
Okay, I've got that filled out. I'm handing that up to the clerk. I really appreciate everyone's time and patience. We'll get through this. We'll get you guys some resolution, some stability, some finality, okay?
Thank you very much.
Your
Thank
Honor,
Thank you.
Yes, go ahead. Yes,
might I ask the parties one quick question, just kind of a housekeeping?
of course.
I have a phone number for, I believe it's Tristan's phone number that ends with 2399. Could somebody verify, either one of you verify that for me? It's an old number and I just wanted to make sure I had it correct.
I think that was the phone number we had for him.
Okay.
Let me see.
And if you don't want to say
His-
it publicly, you can text it to me.
I'll
It's
Thank you.
Well, good, Ms. Hyde, I'm glad you asked that question because it sounds like that information needed to go to all parties. So thank you.
that's not true.
Okay, if there's nothing. Mr. Derby, did you have something you wanted to say?
I just wanted to say that everyone has had his phone number. That's all.
All right. All right, parties, thank you for your time and you're free to log out. We'll see you back on April 15th at 9 a.m.
Thank you.
All right, we'll start at the top of the docket. So Donald Derby and Melanie Vianola. See Mr. Derby here. His height is,
I'm here, Your Honor. Melanie Vianola.
there we are. Okay, great. All right, I've signed an order for adequate cause, which we'll talk about at the end in terms of getting that to a hearing. There's been a report from the guardian ad litem, and I think today we need to look at what kind of parenting arrangement we'll have until we get to the hearing on the adequate cause. Mr. Derby, let me hear from you first, and then Ms. Height, and then we'll go to Ms. Vianola.
Good morning, Your Honor.
Good morning.
I'm hoping that my restraining order will stay in effect at least until we get some finalizing orders from the court. He seems to be doing so much better. He's happy. He's begging to stay at my house. I just feel like right now he's been at my house now for over 2 months and he's really adjusting well. He's liking our routine. So I just hope that the courts will see that Tristan should stay with his father at this time. After he made that CPS report, his relationship with his mother got very volatile. So I'm just concerned. I don't want to see him go backwards.
All right, thank you. Ms. Height, do you want to weigh in?
Yes, good morning, Your Honor.
morning.
I put a couple of recommendations in my report, as you saw, and I do think that it is probably short-term in Tristan's best interest to remain where he is due to some of the disarray that's going on around him right now. I do have some other things I'd like to address with the court as I proceed with my investigation, but I think I'd like to hold off on those comments until after you've had a chance to hear from Ms. Vianola.
Okay. Ms. Fianola, any response?
Yes, Your Honor. You know, I have not seen my son since it's been 2 months solid, and that was prior to a no contact order. And I missed a court date, which is obviously a horrible thing to have happen. And that is when I believe the no contact order came into play. But I don't understand why there was even a no contact order put into play, because I hadn't spoke to Donald via text, phone since March 21st, and it was about an email from the school. And that was the last time I contacted him. So also the CPS report, there's no findings. And this is the third CPS report that he has filed against me. Well, one against my husband that was very, very awful, as well as the one that he claims on me. And there's no findings and no details. And the only thing I can really 100% say about my son is if something happens to him, good or bad, he knows detail for detail, and that could be 10 years ago. He knows what you're wearing, what he had for breakfast. He is very, very meticulous when it comes to things that happen to him specifically. So I don't know how he can continue to violate the plan over and over and get basically rewarded for that. I mean, that's how I feel. He's had no consequences. I don't know what to file. I knew we were going to court, so I knew all this was going to come out. So I really just don't know what to file to say, look, he started this. December 8th was the first time that he started the withholding. And it turned in from just my weekends to solid 2 months. And then all this stuff happened. So I personally believe that Driston would have a better shot if we both were supervised during this report, and Driston went and stayed with my father, who is a mutual person that Dawn feels is a safe home. Driston has a great bond with, and we be supervised, because we've had 2 other GAL reports and nothing has changed, and except that things are being aggressively worse towards me, like I'm becoming a more and more horrible person. It's not about Driston anymore, is how I feel. And that's it.
All right.
And my father is here too as well, if you would like to speak with him at all.
Okay, I'm going to go back to Ms. Height first. Ms. Height.
Well, my comments now, Your Honor, are related to my concerns as the new GAL going forward. As Ms. Vianola just mentioned, I am now the 3rd GAL that the court has appointed. As you can see by the date on the docket notice there, this case has been going on now for 10 years and 2 months. And as I looked back over some of what's gone on before, I have not had time to read all of it, but I noticed, I made notes that there have been parenting plans, temporary parenting plans, amended parenting plans in 2013, 2014, 2015, 2019, 2021, and now here we are in 2023 with currently a 50-50 plan that it doesn't seem to be working. The record is littered with contempt allegations and charges. There's currently, as you know, this restraining order in place. There have been CPS reports, there have been allegations, accusations, denials throughout the pendency of this case. I have not read all of it yet, but of course I will. During all of this, we have now Driston. He's 15 and a half. He's a special boy. He has an IEP at Kelso High for academics and for behavior. He is, by all accounts, doing well in school right now. But he has seen and heard an appalling amount of adult conversation and frankly, parental dysfunction over the length of his life. So as I approach this case, Your Honor, I believe that what I need to do in order to proceed and have a thorough, fair, complete investigation and a report for Your Honor is, I believe after looking back at what we have up to this point, we need a level playing field here. And so this morning I'm asking for two things from Your Honor. First of all, I would like to have both parties have, by the end of today, I'd like to have them both go have a hair follicle 12 panel test with alcohol ETG. There have been allegations about drinking and fighting, and it seems like that's related to fighting. I need to know what's really going on. So I would like the court to order both parties to have a hair follicle 12 panel with ETG and no alteration of hair between now and then. Second, I would like them by end of workday tomorrow to both have made appointments to get a mental health evaluation with collateral input from me. I'd like them to sign ROIs. They can do that at Core Health or Columbia Wellness or wherever they would like to, but I would like to know that is underway immediately. The hair follicle test can be done over, there's the place that I believe can get to it right away would be Occupational Health over across from 15th Avenue Safeway. I pondered this morning whether there should be domestic violence evaluations, and I'm going to hold off on requesting that at this time. But I feel, Your Honor, that in order to do a fair evaluation, I need to get all of us on the same page. So those are my requests this morning, Your Honor.
What would be your thought of having a visit with the mother supervised by her father?
I am in favor of that. Driston is not. As you noted in my report, he said some rather, I would say, severe things during our interview. And I tried mightily to get some variation or some change on that. And that is one of the things I suggested to him and wondered if that would work. He adamantly said he did not want to do that. I personally feel like it's good for kids to have contact with both parents, and I would like him to do that. However, he was very, very stern about what he wanted and did not want. In fact, he did not want to have, even though I recommended it at the end of the day, he did not want to have phone contact either. And so I haven't been able to dig into the bottom of even why he feels the way he does, what's been going on, and what needs to be addressed. So I feel like it's a good idea. I don't know how to make that happen without creating a bigger problem for him. He has been through a lot for a long time, and I'm very concerned about that. One last thing, Your Honor, before I let this piece go is, I know we are due for my final report on May 10th, and I don't think it's reasonable if Your Honor orders the things that I'm requesting today. I don't think it's realistic to expect that to be done and a report to be done and filed in a timely way. I'm going to ask for a delay of probably more realistic than a month. I probably should ask for 45 days beyond May 10th, which would put us more toward the end of June. And it bothers me. When I was talking about a May 10th deadline, it seemed like a more reasonable thing to say, well, let's just leave things as they are until May 10th. But when we're going all the way another 45 days past that, I do think that's an additional very long time for a mother not to have contact with her son. So that's the dilemma that I find myself in this morning, Your Honor.
All right, thank you. Mr. Derby, I'll give you the last word.
I have been trying to ask him if he wants to call his mother or his grandparents, and he's really, really adamantly just does not want to. And I don't know, I don't feel like I can force him to do it. You know, I've left it for him. He has his own phone. And talking about his own phone, last court, we both took an oath. We raised our right hands and said that we would tell the truth. And she said she had never talked with him at all and didn't even know his phone number. And that was false because they'd been having text messages back and forth and talking, and he'd been calling his grandparents. So I just wanted the courts to know that too, on top of everything else. I felt like,
Recently were those contacts?
excuse me?
How recent were those contacts by text messages?
Just before we started the adequate cause.
Oh, recently then.
Mhm.
Okay.
And I think I asked him, I said, did you show your phone? You know, because I wanted him to show the phone so that way maybe the guardian ad litem could see that he had been in communication, and but his mother said that there was none and that I was keeping him from her, and that wasn't true. He has his own phone. He takes it to school. He has, you know, he can do whatever he wants with his phone. So I just wanted you to know that. He is definitely really concerned about being with his mother, and I don't know, there might be a lot more to this than what I even am aware of, because sometimes he's so resilient that sometimes he won't say something because he doesn't want to get someone else in trouble. He's a very nice boy, and I just feel like there's been more to this than what he's letting me know.
All right. Eventually, the contact with the mother may need to occur through some formal reunification counseling. And I'm sitting here, and part of me thinks that I should just require that there be a few hours of visitation during the week with the grandfather involved. But I think I've heard enough today that I might do more harm than good if I do that without some sort of formal counseling to get to that point. So I'm not going to order in-person visits. I am going to require, and this is going to be required on Tristan's part, one telephone call a week to his mother. And you can tell him the court is requiring that. Okay. And, you know, let's make it Thursday night at 7 p.m. That shouldn't get in the way of much in the way of people's activities. So I would like the message to go to Tristan that that's what I want.
Your Honor,
Yes, Your Honor.
I'm sorry to interrupt, Your Honor, but since Tristan and I had talked about this at a recent interview, would you allow me to notify him today of that?
Yes, you may do that.
Thank you.
And he has his phone on at school, and just so you know.
Okay.
And you know, tell him they've got to chat about, you know, mundane things for at least 5 minutes.
Okay.
You know, what's going on at school, what's happening here. You know, I also want to make sure that parents have contact with their children. But I want to be safe about it. Let's go on to some of the other issues. First of all, I'll have Ms. Height's final report due on June 28th.
Okay.
Secondly, I am going to order the evaluations that she has requested. So that means today both parties are to get a 12-panel hair follicle test with an alcohol component. And by tomorrow, a mental health evaluation, if you can get in to do it at either Core Health or Columbia Wellness. Indicate that these are court ordered. Okay. Finally, has this been put on the trial setting calendar to get a trial date for the adequate cause hearing or the new parenting plan hearing? Mr. Derby, do you know?
I'm not aware of any new.
Okay. So what happens after I find adequate cause is that you go to the trial setting calendar and set a trial in order to relitigate the parenting plan. And that will be 6 to 8 weeks after you go to the trial setting conference. So I'm going to require and have everyone show up on the trial setting conference on May 10th. So Wednesday at 1 p.m. And it will be for a one-day hearing regarding your parenting plan. And that will need to be set after June 28th so that Ms. Height can complete her investigation.
Okay, Your Honor.
Now, the final thing I'm going to do, I'm going to set a review before this court on May 17th at 9 a.m. And I'm going to inquire. There's going to be one inquiry from me, and that is after several phone calls with Ms. Vianola, is it possible to have supervised visits after that date? And I just want to check in. I think going from now until likely sometime in July is a long time for Ms. Vianola to not see her son.
I agree.
And I want to be sensitive to what Tristan wants, but I'm thinking if they have a few phone calls, maybe that will change. Also, there's some concern raised about making disparaging remarks to Tristan about the other parent, and that cannot be done. And if I hear of that again, that's going to be a significant concern. Okay.
Your Honor, if I might just trouble you for one more thing.
Sure.
Would you remind the parties to sign ROIs for both of those services? And if they would text me and let me know when their mental health evaluations are scheduled for, that will help me to plan the timing of my investigation going forward. I know those are small housekeeping details, but I think they'll be helpful for me. Thank you.
So at where you get the hair follicle test, you'll need to sign a release of information. We call it an ROI in favor of Ms. Height so she can get that document. And when you do an evaluation at either Columbia Wellness or Core Health, you'll need to sign a similar ROI. Okay. And then let her know when those are completed. Anything else, Ms. Height?
I think that's it this morning, Your Honor. Thank you very much.
Mr. Derby, anything else?
No, Your Honor.
Ms. Vianola?
No, that's it. Thank you, Your Honor.
All right, we'll see you back here then on May 17th.
Thank you.